Primary court. The primary court is at the bottom rung of the inferior court. In the history of court structure, the primary court is incomparatively a new creation which goes back to 1975 with the enactment of the Administration of Justice Law number 15 of 19th century. This piece of legislation, however, was written of the statute book later in 1978. A significant change that was brought about the law number 44 of 19th century was the amalgamation of two branches of the legal profession, doctors and advocates, into one branch called attorney at law as in the United States of America. Another charge that was brought about was the abolition of an age of old institution, the rural court of the village tribunal, and as a matter of fact, the primary court replaced the rural court. Primary court was designed for the settlement of land dispute as well as the adjudication of all claims and the collection of revenue for local authorities. The Primary Court Procedure Act of No. 54 1979 regulates the procedure in the ordinary court and they make provision for connected matters. The Primary Court is vested with both civil and criminal jurisdiction. Unlike the Magistrate Court, it was original criminal jurisdiction in respect of minor criminal offences under the Penal Code. The approach in the administration of the criminal justice is somewhat different in the Primary Court, in that the Primary Court judge is required, where appropriate, by all the lawful means endeavour to bring the parties to an amicable settlement under Section 31 of the Act. This being the aim in the establishment primary courts similarly in civil jurisdiction in respect of causes of action in debt, damage, demand or small claim settlement of matters arising out of enforcement by the law of the local authorities, and since 1986 provincial council with regard to recovery of revenue due to such authorities is the function of the primary court. Section 31 of the Primary Court Procedure Act of No. 54 1979 states, it shall be the duty of the judge of the primary court to inquire orally into the charge and, where appropriate, by all lawful means to endeavour to bring the parties to an amicable settlement. If the party refuses to compound the case, the judge has to proceed to try the case. Mode of the address to a primary court judge is similar to that of the mode of the address in the magistrate court. Land dispute section 66 applications. Inquiry to be held by magistrate under section 72 of the primary court procedure are inquiries in respect of land disputes, and it has been a special area of the work in magistrate court, especially in rural areas. This category of inquiry is treated as quasi-criminal matter in the primary magistrate court. It can be stated with emphasis that section 66 application are of great significance in primary court work. The magistrate associated with the cities and largest towns have a dual role to play in the capacity of magistrate as well as primary court judge. Section 57 of the Judicature Act makes provision for a magistrate to deal with primary court matters in the absence of the primary court judge. Combined court. Some of the magistrate court are combined court to function as a magistrate as well as a primary court judge. As such, a magistrate is required to visit land which becomes the subject matter under section 72 of the primary court's procedure. From compounding to settlement ought to be a norm in land disputes.